Well, good morning, Joe and gentlemen. See, Joe, you're at the foremost. You're not an afterthought like Ed. Okay, so I've been asked to give a bit of a year in review type thing. Actually, my colleague Mark Lynn, I think, is still on his way. Was going to talk about legislation. I'm going to do it in terms of the tribunal and what's been going on in the tribunal this year. Just talk about 2 or 3 cases. Just in terms of what they have been up to, they released their annual report. That's for 2018-2019 just a few days ago. A couple of numbers out of it, as Christmas is all about numbers, usually numbers in the shops and numbers on your credit card. So apparently there were 2,944 home building applications in the tribunal over the 12 months to 30 June 2019. 2,810 of those were finalised, so that's a 95.4% clear-up rate, if that's what you can call it, and only 1% of those were appealed apparently, so that's a little surprising. So excuse me while I grab some coffee. Oh, thank you, Joe. And in terms of where these things take place, there were 375 applications filed in Sydney, 128 in Newcastle. Graham Thorpe's not here, I don't think, today, and 103 out at Penrith. So that's where these tribunal applications get lodged, and usually they get run at the centre that they're lodged. So that's what the tribunal was up to over the last, 12 months to the 30th of June. Now, in terms of useful things that they did, as I said, I just wanted to run through 2 or 3 cases. The first case I want to talk about is a case of Dildum in Developments, Pty Limited, and the owners of Strata Plan 85305. Joe, I can give you the citation in due course. These are appeal tribunals, so the New South Wales Civil and Administrative Appeals Tribunal, their appeal panel, so it's the internal appeal regime. You don't have to go to the Supreme Court anymore unless the amount's big enough. So this was about the much vexed questions of whether you're starting your application in time. As you guys will know, you've got 2 years to start for a minor defect and 6 years for a major defect. When does that period start? Very colloquially, it starts when the building work's complete or the contract's terminated. So been a real problem for a lot of applicants. They often run very, very close to the time limit. And this was, as the name of the case will tell you, an owners corporation. And so far as an owners corporation, the time limit starts when the occupation certificate's issued. Now, in this case, what happened was that there were, in fact, 3 occupation certificates issued. 2 of them were interim occupation certificates, and 1 was a final occupation certificate. And the timing just so happened that the proceedings were commenced such that if either one of the 2 interim occupation certificates were the relevant ones, then the proceedings were out of time. If it was the final occupation certificate, then the proceedings were within time. And the issue here was that the 2 interim occupation certificates, it was said, had been invalidly issued because the occupation certificates can only be issued once mandatory conditions of the development consent have been fulfilled. And it appeared that these 2 interim occupation certificates, classic developer, private certifier, friendly relationship, shall we call it, he'd issued the interim occupation certificates before all the compulsory conditions of the development consent had been fulfilled. So the owners corporation said, well, they're invalid, therefore time didn't begin to run from when they were issued. That time only began to run when the final occupation certificate was issued. At first instance, the member agreed with that and said, yes, that's quite right. If they were invalidly issued, they're not an occupation certificate for the purpose of the Home Building Act. Therefore, time doesn't run until the final occupation certificate was issued. The builder appealed, the developer appealed, went to the appeal panel, and the appeal panel upheld the member and said that that's correct. The time to commence proceedings started from the final occupation certificate, because if the interim occupation certificates, even though they'd been issued, and even though no court or anything else had said no, they're invalid, they've been set aside or anything, nonetheless, if they hadn't been issued in accordance with the legislation, then they weren't valid for the purpose of the Home Building Act. Therefore, time ran from the final occupation certificate. So, the lesson to be learned there, if you're asked as an expert to go and assist either a developer or an owners corporation, is if the time is relevant and it's running from the occupation certificate, have a look at the occupation certificate and see, as far as you can tell, whether or not it has been properly issued insofar as relevant conditions of the development consent have been fulfilled. Because if they haven't, then it's not an occupation certificate for the purpose of the legislation, not an occupation certificate for the purpose of the Home Building Act, and doesn't qualify as an occupation certificate to start the time running. So that was the case back in February, one of the early cases that the appeal panel determined. Yeah, absolutely. Dale. Yes. The interim ones, yep. That's right. So it wasn't fraudulently issued in the sense that it wasn't misleading, in that it didn't say things had been done when they hadn't been done, and that's how they twigged to it. Someone looked, okay, so apparently these things haven't been ticked off. So go back to the development consent. What things had to be ticked off, they had to be. So it's apparent that it wasn't in accordance with the Land Environment Court Act. Yeah. They did. And indeed, Dale, there was a real question in the tribunal as to how far behind the certificate the tribunal had jurisdiction to go, because in fact the only court with jurisdiction to set aside an interim occupation certificate or any occupation certificate is the Land and Environment Court. So one of the arguments in the appeal panel was the tribunal doesn't have the jurisdiction to determine whether it's valid or not. And what the appeal panel said was, well, we've got enough jurisdiction to determine for the purposes of the Home Building Act whether it's a valid certificate. We don't have enough jurisdiction to determine for the Environmental Planning and Assessment Act whether it ought to be set aside. So that was a very relevant consideration. And the reason for that they were able to do it was because on its face the certificate wasn't issued when it should have been issued. The second case I want to take you to is a matter of Allen and Wallace. This was decided just a few days ago in the appeal panel, and this one tackles those questions of the old cost plus contract and variations. Now, in our practice, if clients are smart enough to actually come to us before they enter a building contract and not after they enter a building contract, and they're thinking of entering into a cost plus contract, we always tell them, do not do it. If you can help it, don't enter a cost plus contract. You know, the old carrot will be dangled out there. You know, if I do it on a cost plus, it's going to cost you less, because if I've got to go in on a lump sum, I'm going to allow for contingencies, etc., and it will probably end up costing you more. Invariably, and I mean invariably, every cost plus contract we've ever come across has ended up costing the homeowner more than they expected to pay. As you know, and it's relevant to the decision, in those cost plus contracts there is usually an estimate of what the ultimate cost is going to be, and one of the issues is the builder to be held to that estimate or not. And in the contract it says this is an estimate, but you don't rely on the estimate. The homeowner says, I don't rely on the estimate, which is a bit of a contradiction in terms. It's a bit of a paradox, but that's what it says. Now that was relevant in this case. This was a house at Byron Bay. It was a cost-plus contract, as I say. When the owner first went into the contract, and I'll just dial it up here. Where is it? When the owner first went into the contract, the owner was told the estimate in the contract was $695,000. That was in October 2015. November 2015, the builder revised his estimate and said $796,000 a month later, and then in December 2015, the builder's estimate had increased to $933,000. So, and that's just typical. Part of the increase was a host of variations, and again, you guys will come across it regularly. Variations not in writing, supposed oral agreement to do the variations in some cases, where the homeowner said, well, I didn't even know they were going to do that variation, and then they've charged me. There was also some contention about the builder not being transparent under these cost-plus contracts. The builder's supposed to provide the invoices for the work and then show where the margin's been applied and so on. There was some contention that there hadn't been that transparency, but that wasn't the main part of the case, and not what I want to point out. So the two things that I want to mention in this appeal is firstly this question of the estimate, and the owner said, who terminated the contract, said, I was misled and deceived, because if I'd known that it was going to get up to such a high amount, that the estimate was going to go way over, or the actual cost was going to go so far over the estimate, I would have entered into a lump sum contract for $760,000, and I would have been $200,000 better off if I'd done that. The builder, unsurprisingly, pointed to the relevant clause in the contract and said, well, yes, there was an estimate in there, but clause 30 of the contract says, and this is the standard contract, says if an estimation of the total amount that will become payable is or has been made either before or after the date of the contract, then such estimation will be or have been made on the basis of the information as to the detailed and complete nature of the extent of the works then available to the builder. However, the estimation will not be of any contractual significance whatsoever between the parties, or deemed to be a representation, innocent or otherwise, as to the amount or approximate amount that will become payable by the owner. So the builder relied on that clause. The tribunal said, well, yes, that's all very well, and it may well work contractually, but it doesn't mean that there can't have been a representation that the owner in fact relied upon. And if that representation was misleading and deceptive, then that may well ground an action by the owner for misrepresentation and allow the owner to get some remedy in terms of damages, or perhaps to terminate the contract. So if you're advising either the builder or the owner on a cost-plus contract and a complaint's made that it's gone over the estimate, understand that clause 30, saying that you can't rely on the estimate, is not necessarily a panacea for the builder. The owner can rely on it in some circumstances. The second part, again, which we get all the time, is variations. So there are a number of variations. Again, under the contract, under the Home Building Act, variations required to be in writing, signed by both the owner and the builder. Of course, a number of these variations weren't. They were either in writing but not signed, or they were oral variations. The owner complained about it. The builder said, well, whether or not they were in writing and signed, as the contract and the legislation requires, nonetheless, I did the work, I did it at the owner's request, and therefore I'm entitled to payment on what's fair and reasonable on a quantum merit basis. And the tribunal and the appeal panel agreed with that. They said if you can show that the variation was in fact done at the request or with the knowledge of the owner allowed the builder to go ahead, then the builder, whilst he might not be entitled to a contractual amount, he is entitled to a fair and reasonable amount on the basis of a quantum merit. So that's still out there as well. So again, if you're advising either the builder or the owners, whilst the legislation and the contract might say that variations have to be in writing, and that's a good start, you can nonetheless be up for a variation that's not in writing and signed by both the owner and the builder, provided you've got to show that it was relied on by the builder when he went ahead and did it, that he relied on the owner knowing about it and authorising the work, and secondly, that what's being charged is fair and reasonable. The third case that I want to comment on is one that I haven't been able to, it's only a recent case, I haven't been able to find it in the report, so I only have a report from the press, but that's the case which I'm sure a lot of you are aware of. We've been talking a lot about cladding this year, of course, and this was a recent case in the tribunal where it was found that cladding on some apartments in Ryde, I think it was, were at Putney, in fact, the cladding was found to be dangerous. What's unusual about this case is, one, I think it's the first tribunal case on cladding. Number two, the cladding wasn't aluminium cladding, it was wooden cladding. So that's something a bit different. So this was a material called bio-wood. I don't know whether anyone's familiar with bio-wood. So it's wooden cladding, and the tribunal found that the bio-wood of itself was not necessarily dangerous, but the way it had been applied to these buildings was dangerous, that it would allow for the spread of fire. And what the member said was that it was applied in such a way, and the cladding runs up and down the building between floors, so it would allow the spread of fire between floors. And he said that it created a hazard, allowing the fire to spread, and as we know, he said there was an undue risk of fire spreading via the bio-wood, extending up the facade of the building, which would allow fire to spread into the building. The tribunal is satisfied that bio-wood constitutes an undue risk, and as we know, the Home Building Act describes a major defect as a defect in a major element of a building that's attributable to, amongst other things, defective design, defective materials, that causes or is likely to cause the destruction of the building or any part of the building. So that's where he found it was a major defect. So that was a case, as I said, it's not been reported, so the best I can do for you is to say that it was a decision by Senior Member Boyce, and the parties were an owners corporation, and Fraser's Putney Pty Limited, and the builder was Taylor Construction. So no doubt it'll be reported at some stage, but that's where that was. Dale.
So in that situation, David, there was a
Yep.
and in that situation there, was it the designer, developer, or
Well, as I say, unfortunately I don't have the whole decision. I've only got the press report, but it did say that the tribunal found both the developer and the builder liable. Apparently the owners corporation had put to them via experts that this was dangerous. They said no, it's not dangerous, and the finding was that it is, and so both the builder and the developer. Remember that the statutory warranties or the relevant statutory warranties, that you'll use materials that are fit for purpose effectively, and these were found not to be. So it may be that the developer or the builder had a claim against the designer, a cross claim, or whoever specified it, don't know. We just don't know enough detail, but they were certainly liable under the statutory warranties. Which is a great segue, because I'm going to hand over to Mark now. Before I do, we might have some breakfast. Okay, you set up while I'm having breakfast. Before I sit down, I'd usually finish off my little bit with a bit of a story or something similar. And Christmas, Holidays, so there's the story about the lawyer who goes on his Christmas holidays, finds himself out on a fishing charter with another bloke. They get to chatting. The other bloke's an engineer. This guy's a lawyer, and the lawyer says to him, "Oh yeah, look, I'm out here. I've had a bit of bad luck, which was good luck. I'm here because my house burned down. I lost everything, but the insurance company paid it in full, and here I am. I'm using part of the insurance proceeds for my holiday." And the engineer says, "Well, that's a really strange coincidence. I too am in a similar position because my house and all my belongings were destroyed in a flood, and the insurance company paid up, and here I am." And the lawyer looked a bit confused and he said, "How do you start a flood?" Thank you, gentlemen. Have a great Christmas. No, I don't think so. Oh.
Thanks very much, and good morning everyone. Thanks for having us along again. I'm the other half of the Yin and Yang show with David, and what I wanted to... David tells the jokes and does all the case histories. I don't delve into jokes. I want to talk to you today just about the year that was, but in regards to non-conforming building products and industry reform. I think, as you'd know from my previous presentations, I've got a bit of an interest around the non-conforming products, and in particular in the cladding space, and I've followed that fairly closely. And also then that's led into a lot of reforms and initiatives that have been announced off the back of the cladding fires that are going to lead to hopefully some substantive industry reform, and we've started to see some of that come through already. So what I just want to do is step through a couple of instances and issues that have arisen across this year, and if you'll indulge me, I have to just dive back into some earlier years just to set them up. So I just want to start with the La Crosse fire. As we all know, that was in November 2014, and without going too much into the history of it, that's the fire down in Melbourne where the French tourist went out at night for a cigarette, didn't extinguish his cigarette properly into a plastic container. It ignited the balcony furniture, got in behind the air conditioning, and then set alight the composite panels that were part of the external wall system there. So you can see from that photo, as I say, the composite panel was part of the external wall system, so there was a steel wall frame with insulation and sarking, and then clips and adhesive tape used to attach the panels. The reason I go back to that, even though it didn't happen in 2009, is because earlier this year we got the decision, and this was the one that I alluded to, Dale, where the Owners Court brought an action against the builder, L.U. Simons. There was 211 owners, sought damages of $12 million. They brought their claim based on negligence and breach of contract. Now, the negligence aspect of the claim didn't get up. There was the tribunal down in Victoria found that there was no evidence that the builder hadn't used reasonable care, but certainly that they found that the builder had breached the implied warranties. Now, the implied warranties down in Victoria are very similar to the statutory warranties up here in the Home Building Act, and what the tribunal found was that the Alucobest panels weren't suitable for use as part of the external wall, that they didn't comply with the VCA, and that they weren't fit for purpose. So the end result there was that there was an award made against the builder, certainly in this part of the claim, for the rectification costs, which amounted to about $5.7 million. So the builder was held 100% liable for those based on breach of contract. Then again, as I say, picking up on Dale's earlier question, the builder then joined the consultants that were advising, that he had engaged through the process. Now, some of those consultants had been engaged by way of novation, so they originally contracted to the principal or the developer, and then they were novated across to the builder. And what we see down there is that negligence was established against the three consultants, being the surveyor, or what we refer to up here as the certifier, the architect and the fire engineer. And basically almost 100% of the liability that was attributed to the builder was able to be apportioned through to the consultants. So I think this is the interesting area where this whole issue of non-conforming products will go to Dale's question, who's liable? Initially, is it, yes, the builder and the developer, but then are there any actions at law that arise that can allow for the builder or the developer to join the consultants that he or she engages. So what the tribunal found in regards to the building surveyor is that negligence was established, that the surveyor breached his duty of care because he didn't ensure that the specification met the BCA requirements, and he failed to take reasonable care in terms of giving adequate consideration to the compliance and the suitability of the Luca bond and how it was going to be used on this project. And he found that, and the tribunal found that he failed to investigate the ACPs or even discuss those with the fire engineers. So on that basis, the negligence was established and a failure of his duty of care against the certifier, such that the certifier was apportioned 33% of those rectification costs. So just in terms of liability for certifiers, the fees that the certifier earned in that project were about $80,000. So for an $80,000 job, 56 of that, which was a part of the post-novation period, so the fees that were actually paid by the builder, has resulted in a liability of in excess of about $1.6 million. So there's some lessons to be learnt there about capping liability in contracts, but that's a discussion for another day. Similarly, the architect was found to have breached his duty of care because he failed to ensure that the design satisfied the BCA and failed to ensure that the design was fit for its purpose. And additionally, the architect failed to check samples of the Luca bond that was being proposed to be used. So he didn't check the samples and determine that they accordingly weren't fit for purpose. So the architect got stung with 25% of the liability. Just for consistency, the architect's fees across the project were $1.6 million. And then there's the fire engineer, who was also joined, and as you can see up there, copped 39% of the liability, so got the major share. And again, it was found that the fire engineer had failed to exercise reasonable care and failed to warn the builder that the panels didn't meet the didn't meet the BCA requirements. Interestingly, what the judgment does say, and I'll just read that, the judge does say that unlike a building surveyor or a certifier as we know them, who was described as a generalist, it's the fire engineer that possesses specialist skills in the assessment of risk of fire. Now I just cite that one observation in the case because what we're finding now is when owners of buildings are responding to notices issued by council and there is cladding, obviously you've got to get the new design worked up and get it signed off by a C10 fire engineer. What we're seeing is that even where the cladding verges on that, around that 30% or just under the 30% polyethylene core, what we're finding is that the fire engineers are really moving for the remove and replace option rather than any performance solutions. So I think it's just all part of, it's driven partly by their insurers and their PI insurance, but I think it's also not assisted by comments like those in these judgments that impose, certainly by way of observation, a greater obligation in respect of fire by the fire consultants. So I think that's just an interesting byproduct of this judgment, is that the fire engineers, who are integral as moving forward to rectification of the claddings.
Yeah, I speak to the fire engineer, so the PI insured treatment stuff for the I think that was right for the next report.
Yeah. Yeah, we're finding that the fire engineers very quickly move to the remove and replace option for cladding. They won't certify any performance solutions. So as a result of the La Crosse fire and then again the Grenfell fire, which happened over in the UK, we've seen a number of task forces established around the land. Each of the states, or certainly along the eastern seaboard, have got their own cladding task force. And just an update as at November this year for New South Wales, there's 444 buildings across New South Wales that have been identified as having potentially flammable cladding. Now you might have read a bit of media recently about whether or not the government ought to disclose this list. And to date they haven't, on the grounds that obviously it would have an adverse effect on the value of those properties, and also there might be some additional risk if people are aware that these are potentially flammable buildings. So what we've got here is 444 buildings. You see there across the story levels and a lot of them in that 4 to 8 stories and 9 above, and the number of residential buildings. It's probably fair to say in New South Wales, whilst we've had this information has been collected, as you know, all the owners of buildings where they believed there was cladding on their buildings had to register their buildings earlier on this year. We haven't actually seen a lot of litigation come through as yet, and as David mentioned, there's only been that one case at this stage that's really addressed this question of cladding. But it's probably fair to say that it will come, and it's on its way, and particularly in light of this list of 444. Why has New South Wales only got 444 when Victoria's got some 1,500 odd buildings that have been identified? Some would say because this relies on owners actually registering their buildings. So the extent to which the owners haven't registered their buildings, potentially there are buildings that are not included. I don't know. The Victorian Cladding Authority was a lot more active in terms of actually going out and investigating buildings initially rather than relying on self-reporting. New South Wales has adopted very much a self-reporting approach to this. Yes.
Was that self-reporting?
Yes, it was, yeah. So we've got a matter where a client came to us as a result of receiving a notice from the council with some proposed orders attached, and that's arisen from the fact that this client has actually registered their building as they were required to do earlier in February of this year.
And once they're notified that their building has got these problems, do they have a time limit when they need to rectify?
Yeah, good question. The initial notice is basically requiring the owners of the buildings to then conduct an audit. So this last particular notice, if I just use that by way of an example, gave the owner 8 weeks to undertake an audit. Now, in this instance, the audit was simply limited to the cladding on the facade. It didn't go into the other fire elements of the building. Apparently there are councils, that are issuing notices that require the audit to go a lot deeper than just the cladding and into the actual fire systems of the entire building. And obviously, as you should appreciate better than me, that takes you way into the bowels of the building and all sorts of audit, and a far more extensive audit. But in terms of the time, the initial order requires 8 weeks. Well, this particular order gives 8 weeks to conduct the audit to determine whether or not the cladding met code, and if it didn't, what recommendations would be, what were the recommendations of the fire engineer, and what's the specifications of the rectification work that will be carried out. And at that stage, there'll be significant dialogue. You've also got to discuss with the Fire and Rescue of New South Wales, get them involved as well. There's quite a process. Then obviously it's heading towards significant discussion with council in terms of what is required to do to rectify.
Mark, I noticed you've got 1 to 3 stories there.
Yeah.
4+. I thought it was just the 4+ that was involved in allocation. And the stories below that, I didn't think they were involved.
The Building Product Safety Act, which bans products with polyethylene core of greater than 30%, only applies to buildings 3 and plus. So you can still have effectively you still have combustible cladding on a 2-storey residence. But for whatever reason, these people have owned. I'm not sure that there was a limitation on who had to register their buildings. Yeah. And I suspect based on those numbers that a lot of people didn't. There's none that I'm aware of. There's a couple of class actions that are afoot. A couple of class actions in terms of
fire risk
Yep.
getting the blame.
Yep.
So who inevitably paid? Was it, did it end up being all the insurers?
This instance there were, as I understand, there were insurers standing behind each of those consultants, yeah. But I understand it's on appeal, so we'll see where that ends up. But certainly it's with the insurers.
Okay. Right, so just for my information, maybe what type of policy do you cover? Do you know? Is it PI?
It would be their PI policy. No, the builder engaged under a design and construct contract, you would expect would be a requirement for PI insurance as well. Right, okay. Yep. Yeah, good point. To the WHS legislation, there could be some claims against the manufacturers as well. Yeah.
As a fine, or is that a fine, do you think, or is it a...
Yeah, usually it's a fine.
Yeah, fine.
And also importers. So
Yes. Yep. Okay, best move on. So then, again, rising out of the La Crosse fire, we had this Shergold Weir report, which I've talked to you about previously. That was commissioned in 2017, and in 2018 there was a report called the Building Confidence Report that was handed down. I dived back into these early years for a reason. And the terms of the reference of this report was to examine the compliance and enforcement problems affecting the industry and the implementation of the code. That report, as I say, was delivered in February 2018, and it identified some serious and widespread compliance failings, and it basically concluded that there's almost no effective regulatory oversight in the commercial building industry and no statutory warranties that ran with the property for non-residential buildings. So unlike the residential building where the statutory warranties move with the property, that's not the case in the commercial space. And the findings of this report, and again I put these up because you'll see that they've influenced some further actions by the respective authorities, is that the findings on this report is that there needs to be a greater focus on the responsibilities and accountabilities, education, licensing and accreditation. So you'll see as we move forward that there's a real push for registration of building practitioners, that term being fairly generally and widely defined, quality and assurance. And in the end, the report made 24 recommendations to address these shortcomings. So what happened in 2019? Well, in February 2019, the New South Wales government came out and pledged or indicated its support for the vast majority of these recommendations that came out of the Shergold Weir report. But in particular, they undertook to implement 4 of the major reforms across the industry, they being the appointment of a building commissioner, an overhaul of the compliance reporting, building practitioners with reporting obligations to be registered, and an industry-wide duty of care to homeowners. And the way the report was drafted, there's some suggestion that that should extend out to commercial buildings projects as well, but we haven't quite seen it go that far as yet. So this is the New South Wales government report to the Shergold Weir report, and of course it's fair to say that February was hot on the heels, of course, of the Opal Tower problem, which, as we all know, made a lot of press around this time last year. So it was in December 2018, across the holiday period, when Christmas Eve, was it? Yeah, then people were evacuated or asked to leave that building. And what they found in that building was that the hob beams were under-designed. Well, that was a simplistic view. There may be a more detailed view, but that was what was found. But the interesting point to come out of that for the purposes of today's presentation is that what the final report that was issued to the government in February of this year provided some recommendations, and those recommendations included the creation of a government registered engineers database So again, you go back to the findings of the Shergold-Weir report of having a registration of building practitioners. Here's another example that gives weight to that as a likely reform. The recommendation out of the Opal Tower was that there be a registered engineers database and that there be independent third-party checking and certification of engineering design by a registered engineer, and that there at certain stages be critical on-site inspections of the work by that registered engineer to ensure for compliance with the design. So again, I don't want to harp too much on the actual issues there with the building, but what come out of that is another example and another incident that will support the reforms that are likely to take place in the form of registration of building practitioners.
What is the definition of a building practitioner?
Well, that's a very interesting question. It hasn't been defined as yet, but it certainly looks like it's going to extend beyond just the builder to also design consultants as well. So I think what they're envisaging, as I see it, is some sort of registration and some sort of accreditation of building practitioners, and then there will be certain roles and obligations imposed on a registered building practitioner. And I'll talk later, and David spoke the last time we were here about the design bill that's being introduced at the moment, that's just been out for public comment. It talks about requiring compliance certification by a registered building practitioner at certain stages throughout the project to ensure that projects are in fact being built in accordance with the design.
So that's not necessarily the builder, it's someone overseeing.
Correct. Yes. Right, so then in August 2019 we had the appointment of the building commissioner, David Chandler, and his role is he's going to be responsible for investigation and disciplinary action for misconduct, and also to oversee this concept of end-to-end licensing. So I think the point I'm trying to give you today as we go through all these incidences is there's going to be greater reform in and around licensing, about registration of building practitioners as that term subsequently becomes defined, and also the compliance and checking of design and construct against design throughout the project as it unfolds. And David Chandler's also responsible for driving sort of legislative reform of the industry. Now, he's only been there since August 2019, so it's probably fair to say we haven't seen a lot of what he's to do as yet, but I'm understood that he's been consulting with a lot of various industry stakeholders. One of the criticisms of this appointment, and I shouldn't jump ahead to one of my other slides, but is that it establishes a commissioner, but it doesn't actually establish a building commission. And there's been a lot of talk, and there's a fair weight from the industry itself. Certainly Brian Seiler of the NBA has been a big advocate for establishing a well-resourced building commission. And it would seem that may, should that come into play, sort of take over some of the role of fair trading, if not all of the role, but that's a personal observation. But one of the criticisms about this is that we've got a commissioner, but we don't have a well-resourced commission standing behind that commissioner. Then in November 2019, you'll see that there was the Government Public Accountability Committee that they handed down their interim recommendations into the regulation of building standards and building quality and building disputes. And part of their recommendations, as I said, leading on from my earlier slide, is the establishment of a building commission with adequate resources. So this report has found that, yes, all very well to have a building commissioner, but what's really required is a building commission. A couple of the other recommendations is that the Home Building Act be amended so that the statutory warranties extend to 7 years, and for both minor and other defects. Now, I was reading the actual report, and there was an interesting quote from one of the industry participants who believed that the existing timeframes were too short, and they cited the example that you can get a 5-year warranty for a Hyundai, which has a life of 15 odd years, and yet you can only get a 2-year warranty for the minor, or what we used to refer to as the minor defects for a residential project. Correct. That's right, yes. Yeah, so no doubt the insurers will have something to say about this. Throughout this whole process, and I haven't made this point in today's presentation, but one of the driving stakeholders is the insurance industry. right? When you look at cladding and testing of cladding, the testing agencies are giving the material that they test a rating in accordance with a protocol that's established by the Insurance Council. Again, we talked earlier about fire engineers, and they're leaning towards remove and replace rather than performance solutions driven by insurance and the premiums.
We're not talking about, we're only talking residential here.
We're only talking residential here, that's right.
So we're not talking about any of the commercial.
Not at this stage, no. So another finding or recommendation of this committee was that they extend the definition of defect. Now, they didn't give us a lot more detail around that, but other than to say that. Then, as we talked earlier, the Design and Building Practitioners Bill to be brought forward to March 2020. So they certainly see that there is some value in that legislation. As I said earlier, that legislation has been out for public comment, and I think they were due back in at the middle or end of October. So we'll see whether that gets passed. But that, as David discussed the last time we were here, that introduces this concept of a regulated design and requiring that registered design practitioners sign off that the regulated designs do in fact comply with the codes. Now, what's a regulated design? The devil's in the detail and the regulations, which haven't been brought out as yet. So there's a bit of work to be seen to see how that actually plays out. But certainly the point being here for today's purpose is that there is a significant push to have registered building practitioners and making them accountable and making them sign off on designs if there's a variation, to sign off that the variation is in accordance with a compliant regulated design and meets the requirements of the code. And then there's some consideration of reintroducing the Clerk of Works position on a building project. So that's where we're up to in 2019. I apologise for heading a little bit back into to earlier years beforehand. But Merry Christmas and Happy New Year. Go the Tigers. Every year it rolls around, I think maybe. Thank you.